The Caribbean Sea, long known for its turquoise waters and vibrant cultures, is once again at the center of global tension. This region, often romanticized for its beauty and history, now finds itself thrust into the spotlight for reasons far more contentious and complex. The world is watching as new geopolitical fault lines emerge in these waters, threatening to reshape the balance of power in the Western Hemisphere. The United States has begun seizing oil tankers near Venezuela, a move that has sent shockwaves through international shipping and energy markets. These tankers, often carrying millions of barrels of crude, are now at the heart of a high-stakes standoff that could have far-reaching consequences for global trade and regional stability. American warships intercepting commercial vessels have escalated the confrontation between Washington and Caracas, raising urgent questions about international law, sovereignty, and the rights of nations to control their own resources. The presence of military vessels in these contested waters has heightened tensions, with both sides accusing each other of aggression and provocation. The U.S. claims it's targeting illicit trade that funds terrorism and props up Maduro's regime, arguing that these actions are necessary to uphold international security. However, Venezuela and its allies denounce the seizures as modern-day piracy, accusing Washington of violating their sovereignty and using economic pressure as a weapon. The rhetoric on both sides is intensifying, fueling protests and diplomatic standoffs. With the deployment of the USS Gerald R. Ford and a growing fleet of military ships, the situation has shifted dramatically. What began as targeted sanctions has now evolved into what many describe as a de facto naval blockade, creating uncertainty and fear in vital shipping lanes that connect the Americas to the rest of the world. The risk of miscalculation or escalation is ever present. At the heart of the crisis lies a fundamental question. Are these U.S. actions a legitimate exercise of authority under international law, or do they represent a dangerous overreach that threatens the established international order? Legal scholars and diplomats are divided, and the answer could set a precedent for future conflicts at sea. In this chapter, we'll examine the legal arguments from all sides, hear directly from U.S. officials defending their strategy, and consult maritime law experts to understand what international agreements, especially the UN Convention on the Law of the Sea, actually say about such interventions. The debate is as much about legal interpretation as it is about power and influence. International experts and nations are watching closely, aware that the implications of this standoff reach far beyond the US and Venezuela. The outcome could influence global norms, impact diplomatic relations, and shape the future of maritime security for years to come. Ultimately, this is a test of the principle of free and open navigation on the world's oceans, a principle that underpins global commerce and peace. The world waits to see whether the Caribbean will remain a crossroads of cooperation or become a flashpoint for conflict in the 21st century. Washington frames the tanker seizures as lawful, targeted enforcement of U.S. sanctions against Venezuela and Iran. Officials emphasize that these operations are not random acts, but carefully planned missions designed to uphold international law and protect American interests abroad. The U.S. government insists that such actions are necessary to prevent sanctioned regimes from accessing global markets and using those profits to fund activities that could destabilize regions or threaten U.S. allies. U.S. officials argue these vessels are part of a sophisticated network evading sanctions, funneling resources to governments and organizations that the U.S. considers hostile. By intercepting these ships, authorities say they're cutting off vital financial streams that could be used for weapons development, cyber attacks, or supporting militant groups. The message is clear: the U.S. is watching, and it will act decisively. The legal basis: U.S. courts issue seizure warrants for ships allegedly violating sanctions, like the Skipper, which was linked to Iranian oil smuggling. These warrants are backed by evidence gathered from intelligence agencies and international partners, and are intended to demonstrate that the U.S. is operating within a legal framework, not simply flexing its power. President Trump has openly stated the goal is to cripple Maduro's finances and reclaim lost American investments. By targeting Venezuela's oil exports, the U.S. hopes to pressure the Maduro regime into political reforms and signal to other nations that violating U.S. sanctions comes with real consequences. The message: do business with U.S. adversaries, and you risk losing your assets. This warning is not just for foreign companies, but also for international banks, insurers, and shipping firms who might consider facilitating sanctioned trade. The U.S. aims to deter any entity from helping its adversaries bypass restrictions. Officials say these actions disrupt hostile regimes' financial lifelines, extending U.S. law beyond its borders. By targeting the flow of money and goods, the U.S. hopes to weaken adversaries without resorting to direct military conflict, using economic tools as a form of modern warfare. The U.S. presents this as a global police action, not aggression, using naval power to enforce economic policy. American leaders argue that these efforts help maintain international order and discourage rogue states from violating global norms. The world, however, questions whether this is legitimate security enforcement or overreach. Critics argue that such actions risk escalating tensions, undermining international law, and alienating allies. The debate continues. Is the U.S. protecting global security, or asserting dominance at the expense of international cooperation? The United Nations Convention on the Law of the Sea, UNCLOS, is the foundation of maritime law. It establishes flag state jurisdiction. Ships on the high seas are governed by the laws of the country whose flag they fly. This prevents chaos, ensuring predictable legal order and protecting global trade. UNCLOS allows only narrow exceptions for interference: piracy, slave trade, unauthorized broadcasting, or stateless ships. Unilateral sanctions enforcement is not among these exceptions. The U.S. hasn't ratified UNCLOS, but claims to follow its principles, making its recent actions near Venezuela especially controversial. Critics argue the U.S. is violating the very rules it says it upholds. The heart of the dispute. Does the U.S. have the right to enforce its laws on foreign ships in international waters? The United States often asserts that its actions are justified under its own domestic legal framework, pointing to court-issued warrants and established legal procedures to enforce sanctions. From the U.S. perspective, these measures are not only lawful, but necessary to uphold national security and foreign policy objectives. American courts and government agencies argue that their legal authority extends to enforcing sanctions even when it involves foreign entities or assets, as long as there is a clear connection to U.S. interests or jurisdiction. However, international law experts strongly disagree, emphasizing that no country's domestic laws can override binding global agreements, especially when actions take place beyond national borders, such as on the high seas. They argue that international law is designed to prevent unilateral actions that could disrupt global order and stability. According to these experts, only the United Nations Security Council has the legitimate authority to impose sanctions that are binding on all member states. When the U.S. acts alone, its sanctions are often viewed as coercive, lacking international legitimacy, and potentially violating the rights of other nations. Under the United Nations Convention on the Law of the Sea, or UNCLOS, a ship flying the Panamanian flag in international waters is considered Panamanian territory and is subject exclusively to Panamanian law, not U.S. law, or the laws of any other country. Seizing such vessels without the explicit consent of the flag state is widely regarded as a violation of the principle of freedom of navigation. In some cases, it may even be considered an unlawful use of force under international law, raising serious concerns about state sovereignty and maritime rights. The UN Charter is clear. The use of force is strictly prohibited except in cases of self-defense or when explicitly authorized by the Security Council. Neither of these exceptions applies in most cases involving unilateral U.S. sanctions and ship seizures. As a result, many in the international community see the U.S. as undermining the very system of international rules and norms that it once championed and helped to establish after World War II. This ongoing legal clash highlights a fundamental tension: the reach of U.S. domestic authority versus the principles of the multilateral international order, raising important questions about the future of global governance and the rule of law. There's one narrow legal exception: the stateless vessel. Under UNCLOS, ships without a valid flag can be boarded and seized by any state. This prevents lawless operations and holds rogue actors accountable. The skipper's seizure is notable. Though it flew Guyana's flag, Guyana denied its registration, raising the possibility it was stateless. If proven, the U.S. could justify seizing the skipper under international law. However, this argument doesn't apply to other properly registered ships, like the Panama-flagged Centuries. The US has focused on sanctions enforcement, not statelessness, as its main justification. The stateless exception is a legal nuance, not a blanket defense for the broader seizure policy. Venezuela calls the US seizures piracy, but does the legal definition fit? UNCLOS defines piracy as illegal acts by private ships for private ends, not state actions. The US seizures were carried out by official vessels, acting on government orders for public policy, not personal gain. Legally, this isn't piracy, but it doesn't make the actions lawful. International law experts instead see possible violations of sovereignty, unlawful use of force, and breaches of navigation rights. The piracy label is powerful rhetoric, but the real legal debate is about state power and international norms. The US faces accusations of breaking the rules it helped write. The distinction between political language and legal reality is crucial here. US actions have split Latin America, exposing deep regional divisions. Venezuela and allies condemn the seizures as illegal aggression, vowing to take the case to the UN. Brazil warns a blockade could trigger humanitarian disaster and regional instability. Meanwhile, Argentina and others back the US, seeing sanctions as necessary to pressure Maduro. This support gives the US some diplomatic cover, but the region remains polarized. China, a major buyer of Venezuelan oil, sees its interests threatened, while Europe is wary of unilateral US enforcement. The seizures put global powers in a bind, torn between alliances and legal principles. The crisis is reshaping alliances and testing the region's stability. The tanker seizures are part of a broader, assertive US policy in Latin America, dubbed the Trump corollary. This strategy aims to block migration, fight narco-terrorism, counter China and Russia, and secure regional resources. The U.S. military buildup, including the USS Gerald R. Ford, signals a willingness to use force to achieve these goals. The message to rivals, U.S. dominance in the hemisphere, is non-negotiable. The approach marks a shift from diplomacy to direct action, prioritizing American interests above all. Seizing oil and dismissing international objections are hallmarks of this new doctrine. The result, a more unpredictable and confrontational era in U.S.-Latin American relations. Is the U.S. legally justified in seizing ships near Venezuela? The answer depends on your perspective. U.S. law provides warrants and sanctions, but international law, UNCLOS and the UN Charter, prioritizes freedom of navigation and flag state jurisdiction. Most legal experts say the U.S. is violating foundational maritime principles by seizing properly flagged foreign vessels. The stateless ship exception is narrow and doesn't justify a broad seizure policy. The U.S. is asserting power over international norms, challenging the system it helped build. Many see this as economic warfare, not piracy, but still an unlawful use of state force. The core issue. Does national law trump international agreements in global waters? The future of maritime security and international cooperation now hangs in the balance.